item, Lordship. It's been the first time it's been listed, Lordship. So if this matter can be taken up next week, Lordship.
Yes, who's for the, you're there for the other side. Okay, spread for by the Ms. H. Lalmal Swami, learned amicus curiae for the appellant and not objected to by the other side. Let the matter be listed after 2 weeks.
Deeply obliged.
Yes.
Your Lordship, similar prayer regarding item number 11, Your Lordship. My learned friend has been recently appointed as legal aid counsel for the complainant. She has just received the paper book.
Okay, similar order, okay? Instead of H. Lalmal Swami, you will write Mr. Jonathan L. Silo.
Obliged, Your Lordship.
My lord, if a date could be fixed for that.
They'll list it after 2 weeks, date will come.
My lord,
2025 matter, yes.
similar prayer on item number 10, my lord. My learned friend, Mr.
My lord, I
Rupung
have not
Apautu.
yet received the paper book.
10, sir. Oh, 10.
Sorry, my lord, that's item 13.
If this matter may kindly be taken up after a week, my lord. Item number 10,
This is also 2 weeks, similar.
my lord.
You write Mr. T. Lal Zakima, okay? As per the cost list, amicus curiae. The rest will be remain same.
My lord, item number 13, I am the legal aid counsel
13.
for that matter.
Yes.
I have not yet received the paper book, my lord.
Okay, Miss Emily L. Changte, learned legal aid counsel, appearing for respondent number 2, submits that she has not received the paper book. Stop office to verify and supply a copy of the paper book if the same has not been furnished. List the matter again after 2 weeks on a date to be fixed by the registry.
Obliged.
It's item 13. Okay.
Orders, item 5.
My lord, paper book is received by the parties, my lord. So the matter is ready for hearing, my lord. It's a criminal appeal.
We'll get here, okay? Red flag. Informant. What is this, IE?
This is an application submitted by the respondent number 7, praying for permission to continue the construction of his building. Because Your Worship, his building, although it falls within the Bongkon to Dutlang Road, there are two concrete buildings on either side of his building, which is being constructed by him. On the side towards Dutlang, there's already one constructed building, and on the side towards Bongkon, there's another completed RCC building. So his building is still in the initial stage. He has already planted one pillar, but then due to the digging done by him during the monsoon, there is danger of a landslide. So we had moved this application for permission to at least continue with the construction of the pillars. But this Honorable Court had directed for a spot verification, and the report of the spot verification has been submitted by AMC. They have stated that it will be better if the construction is proceeded further, but not at this stage, after the monsoons. That is the report given by them.
Who is for the AMC?
AMC.
Not for the AMC, and my senior, he's having some emergency, so he's on his way right now.
Who is he? Mr. Zoram Sana?
Yes, my lord.
Okay. There's an affidavit actually.
My Lord, I am appearing on behalf of my senior Joseph. In this IA, for the petitioner, my Lord. And in this IA, my Lord, we want to file a short reply in this case, my Lord. And if this matter may come up again after 2 weeks, my Lord.
Report is there in the affidavit?
They have filed a separate affidavit. It is, I think, filed in 23rd of July. 23rd of July.
Joint inspection report?
Yes.
This is the one?
Yes.
So what is the recommendation here, or what is the finding?
The recommendation, if I take your lordship to page 7, recommendations.
Number 4.
Yes. To mitigate this potential hazard, a retaining structure may be constructed at the cut slope of the existing bench. However, this work involves earth excavation, which could further destabilize the existing soil and potentially triggers landslides. Therefore, the following temporary measures are proposed as immediate precautions along with permanent measures for long-term stabilization. 4.1 Temporary measures. To mitigate the immediate risk of landslide, the following temporary measures are recommended. Current status quo in respect of work already executed may be maintained to prevent any further deep stabilization. Exposed site may be covered with waterproof materials, example silpolins, to minimize soil erosion and prevent water infiltration. 3. Regular monitoring may be conducted to detect any early signs of slope instability by the landowner. Any developments may be immediately reported to AMC. Permanent measures. For long-term stabilization, the following measures may be implemented once monsoon season has passed. Dr. J. Laram Swanger may be permitted to resume construction of the building. The completed structure is expected to reduce water infiltration, function as a retaining wall, and enhance overall slope stability. All loose materials and debris may be cleared to prevent surface instability and to ensure proper drainage. So, Yashib, the permanent measures is that the respondent should be allowed to resume construction as the completed structure is expected to reduce water infiltration. So, Your Worship, that is the suggestion made by the AMC on the basis of the spot verification report.
Okay, what is the page 8? This is the picture of the building.
Your Worship, yes, this on the left side is the construction work which is being carried on by the respondent, and the one on the left, the one on the right, shows the RCC building which is just next to the construction site of the respondent.
This is already constructed,
This is already constructed.
adjacent.
Yes, and there's one on the other side also, which is not shown in this picture.
Okay, and your construction site
It's in
is,
between,
your construction is in between.
the two buildings.
Okay,
This picture does not show the building which has been constructed on the other side, meaning on the right side,
the right side picture is the building on the upper side of your land,
towards Bongkor, towards Dutlang.
Dutlang, on the upper side of your land.
Yes,
And the next comes your land, and below your land is another building.
yes,
Yours in the middle.
completed,
And the left one is the picture of the, what do you call, the
yes.
pillars being erected.
And the Silpolin, if your Lordship will see, we have already covered it with Silpolin.
Okay, status quo order was passed by this court,
Yes,
correct?
yes,
So you have filed this IA now to
Yes.
for permission to continue.
to continue.
Now, as per this verification report, there are two measures, temporary and permanent
Yes.
measures. Permanent measures cannot be done even if it's allowed at this stage.
Yes.
The recommendation is that you cannot do this at this stage because it may further aggravate the thing and there might be landslide. And
So-
the other one, temporary measures,
That,
what
that
have
is
you
being
done?
taken care of, Your Lordship.
you have followed this.
Yes, we have followed this.
It's
We
in
have-
your interest only, isn't
Yeah,
it?
we have covered it with Silpolin, everything is there. So, and regarding this permanent measures, which may be implemented once monsoon season has passed, I'd like to bring to your Lordship notice that there's a notification issued by AMC that during the monsoon period, from 1st of July till 31st of October, no excavation of soil is allowed by AMC because of the danger of landslides.
That is already there.
That is already in place. So even they have stated that once monsoon is over, so even if the Honorable Court grants us permission, it'll be only after 31st of October.
So as on today, we'll grant some time
Yes,
My lord.
because we had the feeling that they should also respond. The petitioner's counsel is there. So he should respond to this. And Mr. Lian Shrima, you are for one of the parties?
Actually, I'm not part of the IA.
IA, okay.
I'm for respondent number 10.
Oh, okay. Today we have to consider IA only, isn't it? Mr. A.R. Malhotra, learned counsel, appears for the applicant and submits that the joint inspection report of the AMC in respect of the land of the
respondent number 9.
respondent number 9, stroke applicant, is filed. Who has filed this?
AMC,
Is filed by the
respondent 7.
respondent number 7, bracket AMC. Stop referring to the report, more particularly at paragraph 4, 4.1 and 4.2. The learned counsel submits that certain recommendations have been made, both temporary as well as permanent. Stop. In terms of the temporary measures mentioned, the applicant has taken necessary steps to follow, to implement the same. Full stop. In respect of the permanent measures, the learned counsel submits that since the monsoon season is on, the AMC has recommended that no earth excavation or earthwork should be done during this season. Stop. He also submits that unless the applicant is allowed to continue, the construction work as prayed for in the application after the monsoon season ceases, 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 comma, the applicant would suffer loss, and also at the same time, it would result in possible landslide within the said area of construction.
This is the notification regarding barring of excavation of soil during the period from 1st July to 31st October, issued by the AMC.
Stop. By producing notification dated 13/6/2025, Mr. A.R. Malhotra further submits that there is already a ban imposed by the AMC for any earthwork during the monsoon season, starting from 1st July to 31st October of 2025. Stop. Therefore, the applicant at any rate would not be in a position to undertake the, to proceed with the construction, even if permission is granted by this court. Next para. At this stage, Ms.
Rosie Manlom Sange, my lord.
Rosie Manlom Sangi, give your name in writing. Okay.
Yes, my lord.
Rosie Manlom Sangi, learned counsel appearing on behalf of Joseph L. Rente, learned counsel. He is the amicus curiae.
Yes, my lord is
Learned
the
amicus curiae for the petitioner submits that she may be granted 2 weeks' time to file a response to the affidavit filed by the AMC. Prayers allowed. List the matter again after 2 weeks on a date to be fixed by the registry. Give your name as well as your senior's name. Okay.
Yes, my lord.
That'll be better. Spelling.
My lord.
Admission item 1.
Me, please, Your Lordship. My Lord, in this case, I was directed to. Sorry.
You want me to record your presence?
Regarding the main case, PIL.
DMC has filed the affidavit with regard to.
No, anything to be said in the main case?
Yes, AMC was directed to file an affidavit with regard to clarification of the status of the respondent number 11. And accordingly, the AMC has filed the affidavit on 29/7/2025.
29/7.
29/7/2025.
Who has filed?
AMC.
Okay. What have you said there? Stated there.
Earlier, the report shows that the respondent number 11 has not made any construction within his landed building. So, as prayed by learned senior counsel, the AMC was directed to visit the spot, and wherein it was found that the respondent number 11 has completed construction of 2 footings of his buildings, and the said land of the respondent number 11 lies outside the declared protected area. So the status of the respondent number 11 has been clarified as per the
Okay.
direction of the court.
This was in terms of which order?
In terms of the order dated 16/6/2025.
Okay. So we'll do one thing. We'll consider this aspect in the next court date. I'll just record that you have filed affidavit. In the main writ petition, please write down.
My Lord, I'll be representing respondent number 25. So, my Lord, I'll be filing my power during the course of the day. Respondent number 25.
Okay, please write. Parties are represented by the respective councils. Your good name?
Reuben Lalrin Sanga.
Who stop? Mr. Reuben Lalrin Sanga. Give your name in writing. Learned counsel submits that he has instructions to appear on behalf of respondent numbers 25.
Yes, my Lord.
Respondent number 25. And that he will be filing his power within
Within the course of the day.
the course of the day. Next para.
So, my Lord, I'll be filing the affidavit in response.
Power also.
Yeah, my Lord.
And affidavit also course of the day.
Yes. No. Affidavit will take time, my Lord.
How much time? 2
Maybe
weeks.
2 weeks.
He'll be filing his power during the course of the day. Full stop. He further submits that he may be granted 2 weeks' time to file his affidavit. The affidavit of respondent number 25. Stop. Prayers allowed. Next para. Mr. C. Zoram Chana, Mr. Zoram Chana, Learned Standing Counsel, AMC, submits that in terms of the court's order dated 16/6/2025, the respondent AMC has filed an affidavit on 29/7/2025 clarifying the status of construction of respondent number 11. Post of the learned counsels for the other parties. Have you all received a copy?
Not yet, my lord.
Learned, Mr. L.H. Dhyanshima, learned counsel for respondent number 11 submits that he has received a copy of the said affidavit. Stop. Let the matter be listed after 2 weeks on a date to be fixed by the registry for further consideration. Correct.
Deeply obliged.
Yes, this is item
Item 1, Your Lordship.
1.
Yes, Your Lordship. So I was directed to file an affidavit to verify whether the directions of these honorable courts have been complied by the state respondents. Accordingly, I have done so, Your Lordship. I had raised 2 issues in the previous court date wherein there was no receipt of payment of fine that was imposed upon the department, the PWD as well as the
Okay.
PHE department. But my understanding is that those receipts were in fact annexed to the affidavit, but it was not available with my copy. That's why I had raised that.
Where are those affidavits? I mean, the receipts?
Your Lordship.
Can you point out?
Yes, Your Lordship.
In which affidavit?
Your Lordship, the receipt for the P&E department is in the affidavit filed on 13/5/2025.
13/5.
Annex number 8, Your Lordship.
13/5?
13/5/2025.
Annexure?
8, Your Lordship.
Page?
Page number 40, Your Lordship.
Page number?
40.
40. And the other one? Receipt of PWD.
P&E, Your Lordship. P&E department.
Yes, that was P&E. Now the next
Yes,
receipt.
Your Lordship.
The other receipt is from
It is from the PWD, Your Lordship.
PWD. Where is that? So you have been served incomplete affidavit.
Yes, Your Lordship. Those 2 particular annexures were not available in my copy.
Your Lordship, this affidavit for wherein the receipt of the PWD was attached was filed on 22/7/2022.
Okay. 22/7/22.
Yes, Your Lordship. Annexure 1.
Annexure 1.
Page number 15, Your Lordship.
Page 15.
15, Your Lordship.
15, okay. So let us verify and see. 13/5/25.
May 6, 27 May and 6th of August. This is 29/7. What was the date?
Your Lordship, for the PWD receipt, it was 22/7/2022, Your Lordship. The affidavit was filed on 27/2/2022, Your Lordship.
22?
Yes, Your Lordship.
This one.
22/7/2020. Page 15.
Page?
An extra one, Your Lordship, page number 15.
Have you got it, brother?
Yeah.
The hand receipt one, and the other one is this one,
Yes, that is.
page 40. The receipts are here, Mr. Fakoma. Would you
Yes.
like to have a look?
No, I've been handed a copy.
Okay, you have seen. Okay. Now, why is it listed today?
It's only for
Apart
that.
from that,
Apart from that, Your Lordship, otherwise everything else is complied as per
Okay.
my records.
see, brother, this matter started because of failure of indiscriminate here and there. We don't hear it again. Okay, many other aspects. As of today, I believe the purpose is very close to close. It's always a law, also an option to reopen law, take up a new matter also if required. As of now, so, subject to what Mr. Fakoma says, I think purpose is served.
Yes, Your Lordship.
Have you received any fee or remuneration in this case?
No,
You have not? Okay. Take care of that. Please, I heard Mr. Lal Fakoma, Lanet Amicus Curie, who has been appointed to assist the court in this matter. And also Ms. Lal Nun Louis, learned government advocate, appearing for the state respondents. So, this court, upon noticing that there has been indiscriminate felling of trees within the city of Aizawl, more particularly in and around Saltlang, Bethel Veng, next to the District Institute of Education Training, Aizawl, bracket DIET, DIET, had directed registration of a suo motu PIL. You'll get the details, order dated 16/12/21, okay? You just check out the spellings and all that. Stop pursuant to the issuance of notice to the state respondent authorities, several affidavits have been filed indicating the reason for such felling of trees and the measures taken thereafter. Stop. The PIL was not confined only to the city of Aizawl, but also to the other parts of the state as well. In terms of the directions passed by this court during the proceeding, the respondents have filed their affidavit giving the fact and figures of the steps taken. And pursuant thereto, deliberations have been made by the parties before the court. Stop. Upon cancel that. Having regard to the response made, we are of the considered view that the purpose of the PL has been served. And the same can be closed. Stop. Next para. On the last court date, that is 30/7/2025, Mr. Lal Fakoma, the learned amicus curiae, had submitted that the PWD the Power and Electricity Department and the Public Works Department had been asked to deposit a compound penalty of rupees 75,429 and rupees 97,840 respectively, in terms of section 29 capital B of the Mizoram Forest Act, 1955, and from the affidavits filed, it appears that the amount has not been deposited. Stop. Today, the learned amicus curiae submits that since he was not furnished with the relevant annexures of the affidavit, he was under the impression that the amount had not been credited to the Forest Department. Stop. He submits that he has been supplied with the hand receipt by the learned government advocate, which indicates that the amount has been credited to the Forest Department. Stop. Ms. Lal Nun Lui, learned government advocate, has also drawn the attention of this court to Annexure 1 no, write like this, to Annexure Roman 8 of the affidavit, of the additional affidavit filed by the respondent numbers 1 to 7 on 13/5/2025, and Annexure 1 of the additional affidavit filed by the state respondents on 22/7/2022 to show that the aforesaid amount has been duly credited, as can be seen from the hand receipt, money receipt. Stop. Upon perusal of the same, it goes to show that the amount has been duly credited. Next para. As already observed herein above, since the purpose of the PIL according to this code has been served, we close the instant PIL. Stop. For the valuable services rendered by the learned amicus curiae, he shall be paid a sum of rupees 50,000 by the government of Mizoram. So stop. The Chief Secretary, Government of Mizoram, shall ensure that the amount is given to the learned amicus curiae without delay.
Deeply obliged, Your Lordship.
Item 2.
May it please your lordships, this matter was last listed on the 17th June 2025, wherein the learned AAG had submitted that the process of handing over the plot of land to District Judiciary Lungle is on and some time may be granted for completing the process. Your lordship, in this regard...
Oh, this is that Lungle case?
Yes, your lordship.
What has happened now?
Your lordship, in this regard, the AG office had actually requested for a status update. However, we have not received any status update from the state respondents as to whether the plot of land has been handed over to the district judiciary or not. So, in this regard, your lordship, if 2 weeks' time may be granted to gather the information, your lordship. We have sought the information way back in May. However, there hasn't been any update, your lordship, in this regard. Therefore, we are going to send a reminder again, your lordship.
You have sought updates from whom?
Your lordship, from the GAD and also from the Commerce and Industries Department, your lordship.
Okay. Mr. Malhotra.
Lordship, this matter may come up next week then. Just getting an update.
Yes.
How long will it take?
Yes, your lordship.
In the meantime, Your Lordship, I'll try to contact the district judge also to find out what is the status.
Mr. A.R. Malhotra, learned standing counsel, Guwahati High Court, appears for the petitioner, and Ms. Lal Nun Lui, learned government advocate, appears for the state respondents. Stop. The learned government advocate submits that in terms of the earlier orders of this court, the Office of the Advocate General has communicated to the General Administration Department as well as the Industries and Commerce Department with regard to the updates on the handing of a plot of land to the District Judiciary Lungle including the land pass. Stop. She submits that she is yet to receive the updates from the two departments and therefore prays for 2 weeks' time to obtain instructions. Stop. However, having regard to the fact that the learned government advocate is required to get the updates only, we grant the learned government advocate a week's time to obtain necessary instructions. List this matter again. Next Wednesday is a holiday, isn't it?
Yes.
Yes, Your Lordship.
On Thursday. Please give the date.
Yes,
28.
28th, Your Lordship.
On 28th.
Much obliged, Your Lordship.
Item 3.
Affidavits are still awaited, Your Honor.
If my lords can grant us 2 weeks' time, my lord.
Affidavit. What is this matter?
No, this is regarding protection of wastelands. It's a PL which has been instituted as per the directions of the Honorable Supreme Court.
Ramsar sites.
Yes, Your Honor.
And in the state of Mizoram, there's a place,
Pala Ramsar site,
Pala wetland. Where is this located?
southern part of Mizoram. Your Honor.
Southern part.
Yes.
Under the MADC area.
Yes.
But they have not appeared, isn't it?
Respondent number 4 notice has been declared to be complete.
That's the MADC.
Yes.
They have not appeared.
They have not appeared.
Now, what are you required to do with this case?
What steps have they taken? The respondents are to file the affidavits to show what steps they have taken with regard to the conservation and protection of the Pala Ramsar site, which is within the state of Mizoram.
Yes, appearance is recorded, but there's no direction for affidavit. What are you going to do? You give us the update. I think the main reason is that there was a writ petition filed in the Supreme Court. Court has said that these states where the wetlands are there should register, the High Court consent should register a suo motu PIL. And so that there's monitoring about the conservation of this wetland. So, Mr. Samuel, I think you'll have to file an affidavit, isn't it?
Yes, my lord.
Who will be concerned here? Who are the respondents otherwise? State Forest?
Yes, my lord. Mizoram Environment, Forest and Climate Change, my lord.
You will be representing 1, 2, 3?
1, 2, 3, and 5, my lord.
And 5.
And 8 as well, my lord.
Okay.
State Wetland Authority.
Okay. How much time should you require?
2 weeks, my lord.
2 weeks?
Yes, my lord.
Okay. And Ms. Zairam Sangpui? Have you received any instructions? Okay, you'll represent which respondent? 6 and 7. And you require 2 weeks too, 2 weeks as well. Okay, please write Mr. A.R. Malhotra, Learned Standing Counsel, Guwahati High Court, appears for the petitioner, while Mr. Samuel Vanarshi Atatsankte, Learned Additional Advocate General, appears for respondent numbers 1, 2, 3, 5 and 8. We'll stop. Ms. Zairem Sangpui, Learned CGC, appears for respondent number 6 and 7. Stop. None appears for respondent number 4, despite service of notice. Full stop. The Learned Additional Advocate General and CGC submit that they may be given 2 weeks' time to file their affidavit. Full stop. Next para, this Suomoto writ PIL has been registered pursuant to the direction of the Apex Code in WPC number 230 of 2001. Stop. The subject matter of the case pertains to preservation of wetlands within the territory of India. Stop. In the state of Mizoram, since there is a wetland under the name Pala, P-A-L-A, Pala wetland, and therefore the Apex Court has also directed the registration of the PIL, as already stated. Stop. As prayed for, next para, as prayed for by the learned councils appearing for the state as well as the Union of India, 2 weeks' time is granted to file an affidavit showing steps taken by the authorities concerned for preservation of Pala wetland and the status as of now. List the matter again after 2 weeks on a date to be fixed by the registry.
Obliged.
Item 4.
Yes.
You have changed your appearance.
Yes.
You look younger now.
Obliged, Your Lordship.
Okay, what is this case?
This case is about the removal of service.
Removal of service?
Yes, a police personnel. Then in the last...
Oh, removal of police personnel?
Yes.
From service?
Service, yes.
Okay.
Then in the last date, a prayer for continuation of delay of 482 days was allowed. And today
482 days?
Yes.
Okay, already condoned?
Yes, already
okay,
condoned.
Good. Now, what is the grounds?
There is a violation of rules 1039.
1039?
Yes. Of the
What does
Mizoram
it say,
Police Manual.
1039?
Yes, it is in page number 16 of my petition, my lord.
16?
Yes.
60?
16.
Oh,
16.
16.
Yes. I have reproduced the rules.
Yes. Please read. What does it say?
After the inquiry has been completed, the person charged shall be supplied with a copy of the report of the inquiring authority and be called upon to show cause within 15 days of the receipt of the report to enable him to make his submission or representation in regards to the finding of the inquiry before the disciplinary authority passes its order imposing penalty. 15 days shall be given to the delinquent for submission of his submission of representation.
So this opportunity was not given.
This opportunity was big, but a complete full 15 days was not given to him.
How many days was given then?
Only 4 days.
Only 4 days?
Yes.
Did you reply?
No, reply was not made.
Why?
Because
You did not have time to react.
Yes, sir. Yes, my
I
lord.
see. And how did the learned single judge handle this issue?
This issue is not handled by the
Is it
learned
so?
single judge. Yes.
But have you raised this in your writ petition? Or you have raising this for the first time?
This is raised for the first time.
Oh, how can that be? You should have raised it at the relevant time.
It is stated. It is stated in the writ petition, but in the affidavit in position, but the respondents in their affidavit in position stated that a copy of inquiry was submitted, was given to me, but
Copy of the inquiry report given to you.
yes, on page 55 it is given to me.
Page
55.
55.
Yes. I have received.
No, it says 15 days.
It says 15 days, but 15 days from the date of issue of this letter. It says in this letter, but the rule says 15 days from the receipt of the inquiry report. That is the difference, Your Lordship.
But you received it on 11th of February.
Yes, I received on 11th of February, but the date of issue is 1st February.
Then what is your reply? You have not replied.
Reply was not made.
Where have you stated your difficulty in submitting a reply within such a short time? Have you annexed the writ petition? No.
No.
You should have annexed a copy of the writ petition in the counter affidavit. What, any other ground?
No such other.
No ground, only that.
Yes, this is the only.
Now,
reason.
question now would be, what prejudice does it cause you? Instead of giving you 15 days, they give you only 4 days. How are you prejudiced?
Because an inquiry, the host the rules is not an inquiry in the eye of law. It says by the apex court.
No, thing is that you file an appeal also, isn't it?
Yes.
Where is your appeal? Is it available? Your appeal? Not writ appeal, your appeal before the DIG or whoever.
Yes, before coming to this court.
Yes, have you annexed a copy of your appeal?
Not annexed here, my Your Lordship.
Have you not filed an appeal?
Appeal was filed,
No, filed.
before filing the writ petition.
Yes.
That was dismissed.
But that is also not annexed.
An order is annexed.
Your appeal before the appellate authority was dismissed, white
Yes.
order dated 8/8/2019,
Yes, 882.
confirming the removal of your service, of you from service.
Yes, Your Lordship.
So what did you state in your appeal? That I have not been given sufficient time to respond to the inquiry report, hence I may be given one more chance, something like that. What did you say
That was not stated, Your Lordship.
then? How can you pick a particular point saying that this was not considered, that was not considered? This is an appeal now. You had all the freedom to raise whatever issues you had to raise before the writ court, before the single bench.
Yes, admitted his misconduct.
And you have also admitted the charge. What was the charge against you? Found sleeping, then loitering, then influence of alcohol, then corrective measures but in vain. There are 5 articles. Let us go to the grounds of your appeal. What have you stated in your grounds of appeal? Page 17.
Yes, 17.
(1039) gross violation. Okay, this is what you have stated. Then inquiry dehodes the rule. Appellant's fundamental right. No. You don't have any other ground apart from that. 1039.
Here he says that paragraph 15 is submitted his reply dated against the so-called notice of proposed penalty from the mobile service.
Para 18.
18.
Mixture 18, 18A respectively.
Page 68. Yes. Is it Indian inquiry report? Against it. But this 15 days requirement is with respect to the second one. Para 17 he says he was instructed to submit representation within 15 days. Thereafter he submitted.
It has a reference letter dated 28th February. 28th February is at page 6. The second focus.
The second photo says 15 days. Yes, I think that 15 days.
It's relying upon the earlier focus of 15 days. But the second time he was replying. The first time he did not reply.
But the ground he has stated is that he was not aware that a reply should be furnished. He hasn't spoken about 15 days at that time. The rule is at page, which one you had quoted? Okay, page 16 now, 1039.
Yes, well, page 16.
But at your paragraph 16, you have not mentioned anything about these 15 days not being granted it to you. You say that you were not aware that any reply was required to be furnished.
On
Your paragraph 16 of the writ appeal.
Yes, in para 23, I have stated. Para 23 of my writ appeal. In page number 15.
Para 23.
Yes.
Okay, that is regarding the first notice furnishing the inquiry report.
Yes, Your Lordship.
Thereafter, you were again given one show for notice
Yes, regarding the proposed penalty.
regarding penalty.
Yes.
Now, here you have not said anything. You admitted to your mistakes. So, same question I am putting you again. What prejudice is caused to you when you have admitted it? Giving you 15 days or giving you 1 month doesn't matter. You have admitted it. Had you consistently said that I require 15 days time, you had not given me 15 days time, give me 15 days time, I'll reply. Even in the second show post. Then I'll answer about the penalty or whatever. You could have said all that. But then you just say that I admit it. Then at paragraph 16 of the writ appeal,
Yes.
page 12. Please read.
That the appellant begs to state that though the inquiry report was furnished to him, he had not submitted his representation against the same, since he was unaware of the opportunity of submitting representation was to give, as he was not given any instruction towards the same, while a copy of the inquiry report was furnished to him, that he, being merely a constable, is unaware of the procedures of inquiry proceedings meted out upon him.
How can you say that? Come to page 55. This is the furnishing of the report. Your signature is here. Second para says, you are hereby instructed to submit representation or disagreement, if any, with the findings of the inquiry officer within 15 days. Failing which, it shall be presumed you have nothing to say. So this was mentioned. How can you say that you do not know? You are a constable.
Yes, Your Lordship.
You are not uneducated. You are an educated person. Because to be a constable, you required to have, what is the qualification required? +2 or graduate? What is the qualification?
Class, it is to be Class 8, class 8 like that.
Class 8.
Yes.
Anyway, class 8 also is good enough. You know how to read and write. So, you are supposed to undergo the basic police training, weapon, drill, all that. These are not just, like oral training. Something, right, instructions are given in writing. So, a lot of complicated stuffs are there. You should know.
Legal training is also given.
Legal training also is given.
My Lord, I'm bringing one judgment passed by this bench regarding this.
Yes, please. Where is that?
We can show here also why the punishment should not be imposed. Any reason for that?
This is the judgment and order. In writ appeal number 2 of 2016, the judgment and order is on 24/4/2017 from para 12 of the said of the judgment. We take up the second ground of challenge at the outset. Under Rule 1039 of Mizoram Police Manual 2005, after the inquiry is completed, the charged person shall be supplied with a copy of the report of the inquiry authority and be called upon to make his submissions of or representation with regard to the findings of the inquiry within 15 days of receipt of the inquiry report. The use of the expression shall indicate the mandatory character of the rule. Therefore, the requirement of the rule is that after the inquiry is completed, a copy of the inquiry report is to be furnished to the charged person, who may submit his response thereto within 15 days of the receipt of the report. It is tried that furnishing of a copy of inquiry report to the charged person before imposing a penalty is not an empty formality. Imposition of penalty is consequential. It follows holding the delinquent guilty of the misconduct charge. The final decision to hold the delinquent guilty of the charge or not is that of the disciplinary authority. In order to arrive at such a decision, the disciplinary authority is required to take into consideration various materials, including the report of the inquiry. The report of the inquiry is an opinion which is taken into consideration by the disciplinary authority. Principles of natural justice require that before any material is acted upon, the delinquent should be given an opportunity to have his say on the material to be considered against him by the disciplinary authority. It is for this purpose that a copy of the inquiry report is required to be furnished to the delinquent, and his response to the same is required to be considered before a decision is taken by the disciplinary authority whether the delinquent is guilty or not. Therefore, reasonable time has to be given to the delinquent to submit his response to the inquiry report, which in this case has been determined as 15 days as per rule. This would be in conformity with the principles of natural justice. If the delinquent is held to be not guilty, the matter ends there. However, if the delinquent is held to be guilty, then only the question of imposition of penalty would arise, which, as noticed above, is only consequential. In the light of the above, that the requirement of the rule 1039 of the Mizoram Police Manual would have to be understood. When the rule says that 15 days time is required to be given to the delinquent to submit his representation, asking the delinquent to submit his representation within 2 days, and immediately on the second day holding him guilty and imposing a penalty was highly unfair, arbitrary, and unjust. Thus, there was a clear infraction of Rule 1039 in this case. It goes without saying that when the law requires a thing to be done in a particular manner, it has to be done in that manner and as prescribed and not in the other way. Supreme Court in Kulwant Singh Gill versus State of Punjab reported in 1991, Supplement 1, SCC 504, had observed that conducting an inquiry, the rule is no inquiry in the eye of law. Even if the delinquent had admitted to the misconduct charge, If the disciplinary proposed to impose a major penalty, it was incumbent on the part of the disciplinary authority to have held disciplinary proceedings in accordance with the procedure as laid down under the law. Failure to adhere to the procedure prescribed had certainly caused prejudice to the appellant, inasmuch as he was prevented from submitting his response to the inquiry report, and without considering his response, appellant was held guilty of committing misconduct and consequently punished, which was in clear violation of the principle of natural justice. Unfortunately, this aspect of the matter was overlooked by the appellate authority. Then on para 18, as discussed above, failure of the disciplinary to grant adequate time to the appellant as per the law to respond to the inquiry report had caused serious prejudice to the appellant. And para 19, in view of the above finding, departmental proceeding against the appellant should now be confined to charge number 1 only. Consequently, it would require reconsideration of the case of the appellant by the disciplinary authority from the stage of submission of response by the appellant to the inquiry report. Resultantly, we set aside the order of penalty dated 4/10/2011, order of the appellate authority dated 17/7/2015, and order of the learned single judge dated 10/3/2016. Appellant now submit his response regarding the findings of the inquiry report to the disciplinary within 15 days from today. Whereafter, the disciplinary authority shall consider the charge number in the light of the materials on record and the response of the appellant, and thereafter pass just proper in accordance with the law, keeping in mind the discussion made above.
So matter was remanded back for
Yes.
consideration, isn't it?
Yes, Your Lordship.
But in this case you have cited, the penalty was imposed 2 days after he was asked to show cause against the inquiry report.
Yes, Your Lordship.
In your case, you did not submit reply to the inquiry report.
Yes, Your Lordship.
Subsequently, you were given a second show cause notice, which was not the case here. In the case you have cited,
Yes.
you've given a second opportunity, which I don't know is whether it is required, even required by the rules. Despite that, you have been granted a second opportunity where you could have given your point of view, but you chose to admit everything.
But
So what is the prejudice now?
the second chance is with regard to the proposed penalty, Your
It is
Lordship,
what?
not on the inquiry report. So I have not saying anything
Maybe,
with regard
but
to
at least you could have indicated, even the inquiry report is defective. I should be given one more chance to reply to that. You have given me only 3-4 days, not sufficient. You could have done that. Instead, you admitted. Now, in the case which you have just cited, facts are different, as pointed out by my brother. The petitioner was given only 2 days' time to reply to the inquiry report. And before he could reply, imposed him penalty upon him directly. So that's why court said that this is not proper. Sufficient proportionality should be granted because the principles of natural justice have been violated. So it was not automatic reinstatement. Court said now you proceed in accordance with law and give him one more opportunity.
But
We find it's distinguishable.
my Lord, and on para 18 it states that failure of the disciplinary authority to grant adequate time to the appellant as per law to respond to the inquiry report had caused serious prejudice to the appellant.
Correct,
It
that is
stated.
correct. But the question now is, how are you prejudiced? If you don't admit till the last minute, till the imposition of penalty, you say, no, I have not done anything wrong, I don't admit. Then we could have said, you should be given chance. But you say that I accept everything. Come to that page 68.
In fact, even at the stage of charge, that also, at that time itself, before the inquiry, you admitted that yes, I have done this, I am improving, so don't proceed.
But on para 15 of the said judgment, this honorable bench, this bench decided that even if the delinquent had admitted to his misconduct charge. If the disciplinary authority proposed to impose a major penalty, it was incumbent on the part of the disciplinary authority to have held disciplinary proceedings in accordance with the procedure as laid down under the law.
Exactly, that's what has been done in your case also. You admitted, but still they proceeded to have inquiry.
But I am
Isn't it?
not given a sufficient time to respond to the inquiry report as per the rule.
Regarding sufficient time, this is not your case in the writ court before the single judge, correct? Did you raise that ground, that sufficient time not given? You please call for this record, Court Master. WPC 89 of 2020. WPC 89 of 2020. We'll take 5 minutes break and come back.
And it seems you have a checkered history, string of punishments imposed that must have weighed in the mind of the authority. Major penalties on the following 8 occasions.
Call the Chairman. We'll do one thing, we'll take 5 minutes break and come back, all right?
Yes,
But to file amendment. पहला है, ठीक।
May I please, Your Lordship, in WPC number 89 of 2020, on page number 13 at para 30, this issue was raised by the petitioner before the single
1-3.
bench. Yes, 1-3, my lord.
Which para?
30. If may I be allowed to read out.
Okay. So you have admitted to the charge. So back to square one. How does it prejudice you? You say that the entire proceeding is like an empty formality. But if you admit to the charge, proceeding conducted is only a formality, ultimately. Because at the end of the day, you admitted, like I said, had you said that, no, I don't admit to any of the charge, I was not given adequate opportunity, I require defense assistance, I want that, I need that, till the last minute, you understand, but penalty was proposed and you said, yes, I've done wrong, henceforth I'll not do any mistake in future. So, given such a situation, what is wrong in the judgment of the learned senior judge? We'll close it. I don't think you have a case, Mr. Pianfil.
Lordship, I am a class 4 government servant with regard. So the lowest one among the government servant. So
you know how to read and write. You know how to protest. You see, you cannot give something blindly like that. I did not do anything. I was not given chance like that. You have to put it in writing. that I have not been given chance, you should have given me this, that, not in the writ petition, during the inquiry. If you had remained quiet, it's a different thing. You had not remained quiet. You had submitted your admission in writing. So on the face of it, there seems to be no prejudice caused to you. It says, with regard to your letter dated so-and-so, I am extremely sorry for all the mistakes I have done, since I am the sole bread earner of the family. I have to take care of my wife and children. So, you should not have done all these things in the first place, if you have so much responsibility. I have to take care of my wife and children, and my father and mother have become aged and old. I have to take care of them too. As such, in my situation, I humbly request to kindly allow me to continue my service so I could continue to take care of my family. Now, if you go to the vernacular,
Your Lordship,
this is an admission.
In fact, the inquiry report itself notes that it appears to be certain enough that this on the voluntary admission of his own guilt by the church official. That is what is noted in the inquiry report also.
Your Lordship, may I be given the benefits of the judgment and order passed in W. Writ Appeal number 2 of 2016, by which the case was remitted back to.
Can you point out any flaw in the inquiry report itself? All right, you did not submit response to the inquiry report furnished to you there. Now what is your response? Can you show why it should not have been accepted by the authority?
No, my
So here also you admit that it is rightly accepted.
Okay, we'll dispose it of, Mr. Counsel. Art Mr. Lalpian Felachongchu, Learned Counsel for the writ appellant, and Ms. Mary L. Kyanka, Learned Government Advocate for the state respondents. To stop. This is a writ appeal filed by the appellant, who was the writ petitioner in WPC number 89 of 2020. Full stop. The writ petition was dismissed by judgment and order dated 7/12/2023. Stop. Aggrieved the petitioners before this court in appeal. Next, Mara, brief facts of the case for the purpose of disposing the instant appeal is that the appellant was appointed as a constable. Where are you appointed? Mizoram Armed Police?
Yes, Armed Police.
In the Mizoram Armed Police, which battalion?
4th IR Battalion.
IR, you are in the IR?
4th IR Battalion. Yes.
Yes, he was appointed as a constable in the 4th Indian Reserve Battalion on 18/7/2008 and was confirmed in service on 28/2010. Stop. A memorandum of charge was issued to him on 18/10/2018, wherein charge was framed against the appellant under 5 articles. So following the same, a departmental inquiry was initiated. And the appointed inquiry officer submitted an inquiry report with a finding that the charge has been proved. Stop. The petitioner was furnished a copy of the inquiry report, white communication dated 1/2/2019, and thereafter with a show cause notice dated 28/2/2019. On the proposed penalty. And on both counts, he was required to submit a response within 15 days. Stop. Although the petitioner submitted his response to the second show cause notice, the disciplinary authority Where is the impugn order?
Page number 66.
This is show cause.
Yes, of course.
Impugn order. Removing me from service. White order dated 1/5/2019. Imposed a penalty of removal from service upon the appellant with immediate effect. Stop. The departmental appeal filed by the appellant was also rejected by the appellate authority. White order dated 8/8/2019. Stop. Aggrieved the petitioner, the appellant filed his writ petition. Next para, the learned single judge White judgment and order dated 7/12/2023. Upon considering the writ petition and the response given by the state, did not find merit in the writ petition and dismissed the same. And that is how the instant writ appeal has been filed. Next para, Mr. Lal Pianfela Chongthu, learned counsel, submits that the appellant was not given sufficient chance to file his representation against the inquiry report. To stop referring to Rule 1039 of the Mizoram Police Manual, the learned counsel submits that after the inquiry is completed, the person charged is to be supplied with a copy of the inquiry report and asked to show cause within 15 days of receipt of the report. On the finding of the inquiry report before the disciplinary authority passes an order of penalty. Full stop. In the instant case, the learned counsel submits that the inquiry report was furnished to the appellant white covering letter dated 1/2/2019, but the same was received by him only on 11/2/2015. Stop. The letter provided that the appellant should submit his representation within 15 days from the date of the said letter, and therefore, the appellant had only 4 days' time to submit his representation. Stop. He submits that before the appellant could submit his representation, the appellant was given a shaken show cause notice dated 28/2/2019 on the proposed penalty to be imposed upon him. Stop. Thereafter, the penalty of removal from service was imposed upon him. Stop. He therefore submits that since sufficient time was not given to the appellant, the principles of natural justice have been violated, and the judgment and order of the learned single judge should be interfered with by this court by passing appropriate orders. Stop. In support of his submission, the learned counsel has relied upon a decision of a coordinate bench of this court rendered by judgment and order dated 24/4/2017 in WA number 2 of 2016, open bracket, Shri C. Malsomzwala versus State of Mizoram and 3 others. Next para, per contra, Ms. Mary L. Kyangte, learned government advocate, submits that the appellant throughout the departmental proceeding was given due opportunity to contest the case. Stop. She submits that not only the appellant declined to have a defense assistant, but he admitted to his guilt, which can be seen from the reply submitted to the show cause notice dated 28/2/2019. Stop. She submits that it is not the case that the petitioner did not have any opportunity to submit his objection or representation against the inquiry report. Stop. Having received the inquiry report on 11/2/2019, 11/2/2019, the appellant could have filed his representation if he wanted to. before issuance of the second show cause notice. Stop. At any rate, the learned government advocate submits that no grievance has been projected by the appellant in his reply to the second show cause notice for not having been given sufficient opportunity to represent against the show cause, against the inquiry report. Stop. Under the circumstance,
Your Lordship, as well as the appeal before the appellate authority. It's in page number 74. Nothing is mentioned.
under the circumstance, you cancel that, okay? She also submits that no such ground has been taken by the appellant in his appeal petition filed before the appellate authority. Stop. Under the circumstance, she submits that there is no merit in the writ appeal, and the same should be dismissed. Next para. The submissions made by the learned counsels for the rival parties have been duly considered, and also the materials available on record. Stop. The sole ground taken by the appellant in the instant writ appeal is that Rule 1039 has been violated, as he was given only 4 days' time to submit his representation. Stop. Reference or reliance to the judgment and order dated 24/4/2017 in the case of Seemal Somzola Supra has been made by the learned counsel for the appellant. To contend that failure to give adequate opportunity in terms of the provisions of the Mizoram Police Manual would vitiate the imposition of penalty upon the delinquent. Stop. We have seen in the said judgment and order relied upon that the facts are not similar. Stop. The appellant in that case was given only 2 days' time to submit his representation, and before he could submit his representation, a penalty of removal from service was imposed upon him. Stop. In the present case, as may be noticed, the appellant was furnished with a copy of the inquiry report via letter dated 1/2/2019, which he received on 11/2/2019. Stop. The appellant did not submit any response to the said inquiry report, and therefore the respondent authority concerned on 28/2/2019 issued the second show cause notice contemplating imposition of imposition of a penalty of removal from service upon the appellant, and requiring him to show cause and requiring him to submit a representation, if any, within 15 days from the date of receipt of the said letter. Stop. The said letter / show cause notice was received by the appellant on 6/3/2019, and in response he submitted his representation on 13/3/2019. Stop. In this reply, the appellant stated that he was extremely sorry for all the mistakes he had done. Since he was the sole breadwinner of the family and to take care of his family, he requested the authority concerned to allow him to continue in service so that he can continue to take care of his family. He also promised not to misbehave in future. Full stop. As can be seen, the appellant has plainly admitted that he had committed wrong. And despite and that he had not raised any grievance in respect of not having been given sufficient time to respond to the inquiry report which he received on 11/2/2019. The appellant has also not made any grievance in this regard in his appeal filed before the Deputy Inspector General of Police within bracket Northern Range. On what is the date of the appeal? There's no date.
It's not dated, yes, Your Lordship.
The so-called notice was issued on 28/2. So till 27th at least he had, from 11 till 27 he had time to file. He did get 15 days.
No. This is the inquiry report, isn't it? 1st February. He received on 11/2.
Then subsequently this
It says
next order was issued on
it says 15 days from the date of issue of this letter. It has to be counted from this date. That means 15 or 16. But then, even if there's a delay, you could have said that. You still filed saying that.
Because the subsequent to so-called was issued on 28.
Correct.
Then he could have filed.
Correct. What did I say last? Dated Samso. No date, isn't it? We have further noticed that the forwarding letter by which a copy of the inquiry report was furnished to the appellant is dated 1/2/2019 and which was received by the appellant on 11/2/2019. Although the letter says that the appellant was required to submit his representation or disagreement, if any, with the findings of the inquiry officer within 15 days from the date of issuance of the letter. But the appellant could have submitted his representation, etc., if he wanted to. Prior to issuance of the second show cause notice dated 28/2/2019. Not only has he failed to submit his representation, but he has also failed to mention that he was not given sufficient opportunity to submit his representation against the inquiry report. And in fact, he has admitted to his guilt, as can be seen from his reply to the second show cause notice submitted by him on 13/3/2019. Stop. It therefore appears that no prejudice has been caused to the appellant for not having been given 15 days' time to submit his representation against the inquiry report. Stop. Next para. Thus, upon due consideration, we do not find any ground to interfere with the order passed by the learned single judge, and accordingly, the writ appeal stands dismissed.
Please, Your Lordship. Your Lordship, with regards to the recording of the facts, may I just submit one thing, Your Lordship?
What?
That there is a supplementary charge. At the time of recording of the facts, Your Lordship have mentioned the article of charge, 5 article of charge, but then there's a supplementary.
How many supplementary charge?
1.
Page?
It's page 46.
Okay, just turn back the pages. You must have seen somewhere the memorandum of charge I mentioned. 5 article of charge. Isn't it? Could you find it?
Five or four?
That's it. I think 5.
There's in original, the first one, there's 5 article of charge, but then there's a supplementary charge, another one article of charge, which is in Annexure 10, page 4.
What is that supplementary?
Influence of alcohol while performing duty, page 47. This
4 supplementary charge. How many article of charge is there in the supplementary?
1, just 1. Your Lordship.
What is that?
In page number 47,
Yes.
statement of article of charge framed against so-and-so, article 1.
There are 4 supplementary charges, Your Lordship.
4?
Yes.
What are they?
It is in WPC 89 of 20.
No, come to your appeal, page 47. This is the supplementary. We see only 1. Statement of article of charge frame against so-and-so, this is 1. Statement of imputation, this is the same repetition of the same thing. So there's only 1. How do you say there's 4?
Oh, okay.
There are 4 annexures. This is what you mean, I think. It's not article of charge. This is annexure only. Annexure 1, 2, 3, 4. You write somewhere at the bottom. In addition to the 5 article of charge, comma, the appellant was also
Your Lordship, the supplementary charge memorandum starts from page 30.
issued a supplementary charge memorandum on 13/11/2018. This you insert, okay? Somewhere in the beginning I have given that 5 article of charge. After that you can just add that one.
Your Lordship, it starts with page number 38, supplementary charge memorandum. First was issued on 25 October 2018. 1 article of
There are
charge.
multiple supplementary
Yes, multiple. Four supplementary.
But just read
charge.
supplementary memorandum number
Just-
3.
And then another one is supplementary charge memorandum 2. So there are 4 supplementary charge memorandum.
Okay, separately.
Yes, separately. The first is on,
S42 is supplementary memorandum 2. Then again,
Yes.
yes.
It starts from page
Okay.
38.
Show me, where are the other supplementary charge?
Page 38. and
One is
also
46, then the other one is 38, and what about the others?
42.
Two more.
Page
42.
42, 46.
It starts from
And
another 6, page 30.
42,
Page 38,
no, 42 also.
42.
the second one, second supplementary.
second.
Then,
And third is 46 and fourth is 50.
Oh, there is a fourth also. That is why the impute judgment.
Yes. Separately.
no, please repeat again. One is 38,
One is 38,
then
second is 42,
42, then
and
third
46 and
46.
50, 50.
50 also.
Yes. So altogether four.
Okay.
Four separate.
I was just seeing one of the supplementary charge, that's
Yes.
why.
It's my mistake. Your Lordship.
Separately they are, then you rewrite that again. In addition to the 5 article of charge, the appellant was furnished with 4 other supplementary charge memorandum. On 25/10/2018, 31/10/2018, 13/11/2018, and 28/1/2019. Okay.
Hearing item 8.
Yes, what is this matter?
Please, Your Lordship. May I please, Your Lordship?
Yes.
My Lord, sorry I could not come before Your Lordship at 10:30 because of some technical issues. My Lord, this matter was fixed. I came to know yesterday only. The matter was came up. Kindly see the last order of 19/6/2025. Where the matter was fixed for 15th of 7/2025 for hearing.
Which order? Order dated?
Order of 19/6/2025.
Okay. Yes. 14/7.
Yes, well, that on that very day, the reasons were being reflected in the order sheet. Why the matter could not be taken up for one or the other reason. And accordingly, the matter was fixed on 14/7/2025 with the convenience of all the councils, where the Lanet AG was also there. Now, for one or the other reason, it was not even listed on 14/7, if I am not wrong. And yesterday I came to know this matter is fixed today. And the problem is that the instructing council, he is not present in ISOL. So I would like to place some authorities and all. I am being handicapped at this point. So what I am proposing is that, subject to what my learned colleagues at the bar, is that let the matter be fixed on 26th of this month, so that we can finish up this matter. Because for me the issue is very simple in this matter, that whether a person can occupy 2 posts. Because whether the respondent number 10, he can continue to occupy two offices, one as a member of the Autonomous Council and as the member of Legislative Assembly of Mizoram. That is the main issue.
Okay, what is the convenient date, Mr. Deb, for you?
My lord, since my learned friend is proposing for next week, and since there will be a division bench on Thursday, I am told.
Yes.
Most probably on Thursday, because Wednesday is a holiday.
Wednesday holiday. So, if it can be fixed on Thursday, I can come on Wednesday, and I can argue the matter.
I'm so sorry, sir. Sir, my lord, on 20th, I have a fixed matter in other High Court. Physical hearing is required in Delhi. So after...
Then let us have it on 3rd of September then.
3rd of September, my lord, 3rd of September, I have some personal difficulties. I may be excused.
Okay,
September then, sir.
come to an agreed date.
Any date after 5th of September. I would also like to come to Aizawl bench physically. New building is, I have never been there.
You are most welcome.
Yes.
So, see, we'll do one thing. Which date will be convenient to the parties? I think you come to a consensus and inform the court and we'll fix accordingly.
My lord, that can be done. That is fair enough.
Parties can just have
You
a
are
vote.
okay with 26th, Mr.
26.
26 I am fine, sir. 26 I am fine.
26th.
26 of this month I am fine, sir.
No, see, unless
So
there
then
is, unless there is some urgency in the matter, I think it will be better to have it in the first week of September, any convenient date.
My lord, after 6th.
September I am fine, my lord. After 3rd.
My lord, after 6th of September.
Okay. It does not necessarily to have to be on Wednesday. If you want it, we can have it on any particular date also. Then,
Well, in that case, if the learned AG agrees and my brother, Mr. Malhotra agrees, can we have it on 11th of September? That's a Thursday.
no, if not otherwise inconvenient, we can have it on 10th. We might have it on 10th because other matters will be taken up on that day also, division bench matters.
Then let us have it on
September.
10th of September.
10th of September.
My lord.
Okay.
My lord.
Obliged.
As agreed to by the parties, let the matter be listed for hearing on 10th of September 2025.
Obliged.
Yeah, please.
Item 9.
What happened to item 7? Item 7 was adjourned.
Item 7, we have already done it.
Already adjourned.
Yeah.
7, I think we have done already.
Oh, it was that thing, no?
That is
That,
with
construction thing.
Promoter, with IA.
Okay. Item 9. Mr. Pianfella,
Yes.
you are the appellant.
Yes, I am for the appellant, yes.
See, I think you have about 4 minutes before break. Should we have it in the afternoon?
Yes, Your Lordship.
You are ready?
Yes, Your Lordship.
You are for the state and you are for the informant. Pokso?
Yes, Pokso.
Okay. Brother? Afternoon. No, I don't have.